This week's video is about assault cases in the District of Columbia. We get a lot of questions when people contact us about whether their charge for assault is a felony or a misdemeanor and what the differences are between the two charges. My name is Joseph Scrofano and I'm the founder and managing partner of Scrofano Law PC, where we fight relentlessly on behalf of anyone in trouble who cares about their future. We represent clients in the District of Columbia, Southern Maryland, and Northern Virginia. Collectively, we have handled hundreds of assault cases over the years. In DC, there are multiple assault offenses that you could be charged with if arrested. Two of the most common are misdemeanor assault and felony assault with significant bodily injury. There are many differences between the two crimes, including the added element of significant bodily injury to felony assault. The maximum penalties are also different, and whether the defendant is entitled to a jury trial is different as well. However, there are some similarities between the two offenses. For example, the U.S. Attorney's Office for the District of Columbia prosecutes both offenses, and the same defenses are available for each offense. So, first question. What are the maximum penalties for felony and misdemeanor assault? The main difference between the two are the potential maximum penalties and the requirement for felony assault for the defendant to have caused significant bodily injury. Simple assault is a misdemeanor charge with a maximum penalty of 180 days and or $1,000 fine. Assault with significant bodily injury carries a maximum penalty of up to 3 years in prison and a maximum $3,000 fine. Now, who prosecutes assault cases? Both felony and misdemeanor assault cases are prosecuted by the United States Attorney's Office for the District of Columbia. An assault is basically just an unwanted touching of another person. Whether someone gets charged with felony ultimately turns on the question of whether the complaining witness suffered significant bodily injury. Now, in many cases, the police may arrest someone or obtain an arrest warrant for the felony assault charge, and the prosecutors may ultimately make a decision to charge a person with only a misdemeanor. Now, who decides whether to charge misdemeanor or felony? Whether the case is papered as a misdemeanor or felony is ultimately going to turn on some pretty inexplicable decisions. For example, we've seen cases where the complainant suffered a broken nose and the individual was charged with felony assault. On the other hand, we've seen cases where the complainant had both of their front teeth knocked out, and the prosecutor only charged the defendant with misdemeanor simple assault. So there's some pretty inconsistent decisions coming out of their office. There's diversion available for assault. The government may offer something called a deferred sentencing agreement, where the defendant pleads guilty. They defer sentencing for a period of 6 months, and if the defendant successfully completes 48 hours community service and does not get rearrested, the government will not oppose a motion withdrawing the guilty plea and ultimately dismiss the case at sentencing. That would result in a dismissal of the charges. The prosecutors will not typically offer diversion cases where the defendant is charged with a felony assault. Can you get a jury trial for assault charges? This is another good question, and another major difference between simple assault case and the felony assault is the misdemeanor offense is not jury demandable. That means if the case goes before a trial judge, and the judge alone will decide whether the defendant is guilty and if the government proved their case. A felony assault, like all felonies in the District of Columbia, are jury demandable, where you would have a jury of 12 strangers who would sit and make a determination whether they believe the government proved every element of the offense beyond a reasonable doubt. Now, it's important to point out that the U.S. Attorney's Office for the District of Columbia like to play this game where they amend the charges to deny the accused a right to a jury trial. To get trial by jury in D.C., the offense must carry a maximum penalty of more than 180 days. Now, most misdemeanor offenses carry a maximum penalty of 180 days and so are therefore not jury demandable. Of the few misdemeanors that are or do carry a maximum penalty of over 180 days, the government always amends the charge to attempt whatever the offense is, because the general attempt statute in the District of Columbia carries a max penalty of 180 days. In fact, in 2016, the DC City Council amended the assault on a police officer offense to specifically make it jury demandable. However, the government has found a way of getting around the defendant's right to a jury trial in that case by amending the charge to simple assault rather than assault on a police officer. What defenses are available for assault cases in the District of Columbia? Many of the defenses remain the same. whether the crime is charged as a misdemeanor or a felony. For example, self-defense, defense of others, and mistake of accident are all available defenses for either charge for simple assault or assault with significant bodily injury. In a self-defense, the person must subjectively fear an imminent danger or bodily harm. And in order to protect oneself, it must be reasonable. The force used must be reasonable. Therefore, if the complainant suffers significant bodily injury, usually that will involve greater force used. So in those cases, to have a strong case for self-defense, the facts and circumstances must show that the defendant's subjective fear was reasonable and that the use of that kind of force was reasonable under those circumstances. Now, the same goes for the defense of mistake or accident. If the complainant suffers significant bodily injury, then the facts and circumstances must show that the defendant harmed the complainant by mistake or accident, and that mistake or accident caused the significant bodily injury. For example, if you trip on the metro and knock a stranger over and they suffer a serious bodily injury, it's because you didn't intend to touch that person and you did it by mistake or accident. You would have a defense to either simple assault or assault with significant bodily injury. Now, what are some of the type of assault offenses that we have seen in the District of Columbia? First, it's important to understand that if you were charged with assaulting someone who you're in an intra-family relationship with, then the charge will be held in domestic violence court, and we'll do a separate video explaining the ins and outs of domestic violence court. However, the most common scenario we see, aside from domestic violence incidents, are where an individual gets into a physical altercation at a bar or nightclub, usually involves alcohol intoxication. Oftentimes, one of the individuals will flee. Police will investigate the case to try to get an identification of the individual who fled. And in those situations, the person who sticks around and gets to shape the narrative with the police. And so even though the person fleeing may have totally been acting in self-defense, the police will seek a warrant for their arrest. Now, something to keep in mind in these types of cases that happen in bars or clubs in DC is that most bars and clubs have security footage in their establishments. So getting a request to the establishment to preserve the video evidence can be crucial in an assault case. In the above example, for example, the person fleeing the scene may have acted in self-defense, and police may have just basically took the complainant's word for it, got a warrant for their arrest, and having an attorney make sure that the establishment preserves that video evidence can be crucial for the evidence in the trial. Now, if you or a friend or family member have been arrested or under investigation for simple assault, give us a call or click the link below to schedule a full case evaluation by an experienced criminal defense lawyer in our firm. Otherwise, if you don't have a case and you just like learning about criminal law, go ahead and hit the like and subscribe button, as we'll be discussing a number of legal issues in the future, including cannabis laws, gun laws, and traffic laws as well.